Good morning, everyone. Can you?
Sorry,
I don't think my voice is
you
quite.
probably need more than I do.
Now, can you guys hear me? Good morning, everyone. Okay, so I'm here to talk about something that everybody loves, litigation, and some of the changes that have taken place following the Appellate Reorganization Act of 2021. So previously, for workers' compensation claims in West Virginia, the court of original jurisdiction was the Office of Judges. Effective July 1st of 2022, the Office of Judges was replaced by the Board of Review, which is now the Court of Original Jurisdiction for workers' compensation claims in the state of West Virginia. So previously, the Office of Judges was comprised of administrative law judges, or ALJs, and a chief administrative law judge, and those administrative law judges would hear evidence in a case, and they would be the ones issuing decisions. The Appellate Reorganization Act changed that process a little bit. So the Board of Review is now comprised of 5 members, and each member hears all objections in any case assigned to him or her throughout the life of the case or the member's term on the Board of Review. And just a kind of a small note of interest, previously with the Office of Judges, if a claimant was disputing a claims administrator's order, that was referred to as a protest. I'm not sure why, but that formal term is now changed to an objection. They're called objections at the Board of Review rather than protests. Everybody kind of still calls them protests, but from a formal member, they're actually called objections. So those 5 members that are currently at the Board of Review, they were all appointed by Governor Justice, and they serve 6-year terms. No more than 3 members of the Board of Review can be of the same political party, and each member of the board had to have at least 10 years of legal experience, and specifically 5 years of experience either litigating cases or hearing cases as a judge. And I believe all of the Board of Review members, at least 3 for certain, have several decades of experience as attorneys and specifically workers' compensation experience. And so each member of the board had the discretion to hire hearing examiners that would be specifically assigned to that specific member of the board. And those hearing examiners were hired to assist in the administration of litigation for a case. So essentially, if a board member assigns a case to a hearing examiner, that hearing examiner will take care of all the procedural issues involved with that case. So they will, if there's a hearing scheduled, the hearing examiner will be the one that hears the testimony. They will review the initial evidence and testimony, and they give all that designated record to the board member, and the board member is the one that actually issues a decision, but the hearing examiner can make recommendations as to what they think the decision should be for that case. And so it's interesting that all of the hearing examiners are, like I said, they're only assigned to a specific board member, so essentially the Board of Review is kind of operating like 5 distinct courts, because there's not a whole lot of interaction between the hearing examiners and other board members. They all kind of are each separately contained and each issuing their own specific decisions. And so I just wanted to note some kind of general trends we're seeing with the Board of Review as opposed to the Office of Judges. So generally speaking, the board seems to be very claimant-friendly on issues of compensability. A lot of those cases, if we have denied a claim because we don't think it's compensable, we're seeing that it's being overturned by the Board of Review. When it comes to issues such as indemnity benefits or medical treatment authorization, things like that, it's a little bit more even. But so far, they are being very claimant-friendly for compensability issues. So prior to the Appellate Reorganization Act, West Virginia was actually one of the only states that did not have an intermediate court of appeals between trial courts in the state and the state Supreme Court. And now that we have the new act, the intermediate court of appeals is now the appellate court that will hear most appellate issues from trial courts before it goes to the Supreme Court of Appeals. Although I believe that criminal issues are still directly go to the Supreme Court. So the current judges for the ICA are Judge Thomas Scarr, Judge Daniel Greer, and Judge Lawrenson. These were all appointed by Governor Jim Justice for their initial term, and those initial terms are staggered to end at the end of 2024, 2026, and 2028 respectively, so that they can keep some consistency among the court, and there won't be elections for each specific judge at the same time. So after those initial appointments are over, those judges will be elected and they will serve 10-year terms. And just as a note, so at the intermediate court, there is no new evidence or testimony. So all that the intermediate court reviews is the designated record that was submitted to the board of review. They review that evidence. They can decide if an oral argument is necessary. Parties can request oral argument. Ultimately, the judges are the ones to determine whether they think oral argument is necessary for the case. And generally speaking, for workers' compensation claims, it's not. And then there also, as a note of interest, there's no filing fee for workers' compensation cases. Generally, for intermediate court appeals, there's a $200 filing fee, but they decided to waive that for workers' compensation issues. So the ICA can either affirm the Board of Review's decision, or they can reverse, modify, or supplement that decision. And they can also decide to remand the case back to the Board of Review for further processing if they feel that the Board of Review did not adequately analyze a certain issue or evidence in the case. And if the Board of Review does decide to reverse or vacate one of the Board of Review's findings, it's got to be based on one of those 6 factors. And generally, it's going to be that clearly wrong in view of the reliable, probative, and substantial evidence on the whole record. Most of the time when we see a reversal by the ICA, it's going to be because they felt that the Board of Review's decision was clearly wrong. And that can be because it's based on speculative evidence, or it's just they thought that the evidence was not, or the Board of Review's decision was not supported by the evidence of the record. So written orders from the ICA are now binding precedent over the Board of Review, unless that decision does go to the Supreme Court and the ICA's decision is overturned by the Supreme Court. One significant difference between how litigation previously was conducted for workers' compensation claims and how it is now with the Reorganization Act is appeals to the Supreme Court used to be of right because it was the only appellate court in the state. But now the Supreme Court appeals are discretionary, so the Supreme Court can decide that they are not going to hear an appeal if they don't think it's necessary, or that there's legal error in the intermediate court's decision that would require review. So I wanted to include a couple of intermediate court decisions that I felt were notable. As a general matter, we're seeing that the intermediate court is not overturning the Board of Review's decision very often. More often than not, they're going to affirm whatever the BRR found in the case. But there have been some notable decisions in which they did reverse, and a few where they affirmed the Board of Review's decision and provided some significant analysis to kind of give us an idea of how they're going to decide these cases if it does go to them again. So because we're getting into the time of year where everybody's sick and COVID cases are ramping back up, I wanted to include 2 of the cases that the intermediate court did review for COVID. The first one was Prime Care Medical West Virginia v. Brittany Foster. Ms. Foster was a health services administrator for Southern Regional Jail. She did COVID testing. She administered COVID tests to inmates and staff at the jail, among other things. They had a staff meeting at the jail, and thereafter the staff members were informed that a couple of people had tested positive for COVID. So everyone who was at the meeting was sent home to quarantine for a couple weeks. And during that quarantine period, Ms. Foster was participating in non-work-related events. So she went to the zoo, she visited somebody in the ER, she was doing several things outside that could have potentially caused her to contract COVID. And so lo and behold, she did end up getting COVID, and she filed a claim alleging that it was resulting from her coworkers who also had COVID. Well, the Board of Review actually, I should back up. So the claim was denied by the claims administrator on the basis that COVID is an ordinary disease of life that she was equally exposed to in the general public. But the board of review actually reversed that decision and they found the claim compensable. But the ICA provided a pretty detailed analysis of this case on appeal, and they ultimately found that the board of review's decision was insufficient because they did not properly analyze the case under West Virginia law. So in West Virginia, when the COVID Job Protection Act was enacted in March of 2021, that did not include any kind of rebuttable presumption for workers' compensation purposes. So there was no presumption that a health worker or any essential worker contracted COVID through their employment. And because of that, all COVID cases have to be analyzed under current West Virginia law, which is no ordinary disease of life is going to be compensable unless it meets the 6 factors for an occupational disease. And so the board of review, the ICA found that the board of review didn't do any kind of analysis of those 6 factors. It kind of summarily stated that they felt that the claimant had met their burden. And so the ICA found that decision was insufficient. They vacated the order, remanded it back to the board of review to consider the evidence and do a detailed analysis of each one of those factors and whether the claimant established her burden to find the claim compensable. And so there was a separate case, Von Hutchinson v. Raytheon Corp. Mr. Hutchinson was not a healthcare worker, but he was deemed an essential worker during the pandemic, and he continued working in the Raytheon facility with approximately 35 other people. Same kind of scenario, some members contracted COVID, he ended up getting it thereafter, and he also filed a claim for benefits alleging that he contracted COVID through his coworkers. In this case, the claim was denied, and this was actually initially by the Office of Judges before the Board of Review replaced it. The Office of Judges denied the case as well. It affirmed the claims administrator's order, and the ICA found that that was appropriate based on the same reasoning as it did in prime care, that it's an ordinary disease of life, and unless it meets those 6 factors for an occupational disease, the claim should not be found compensable. So generally, I don't think many COVID claims are being filed anymore, but it's good to know, and I think that the intermediate court decisions have played a hand in that, and that now claimants counsel across the state knows that they're going to have to meet those 6 factors for an occupational disease if in order for the claim to be found compensable. Yes.
I happen to be one of the people who was sent home because of Brittany Foster's.
Oh,
I was in that room. They brought that to us from Ohio and Pennsylvania. They brought it into our facility.
COVID?
Her supervisors, I'm the HR, I did their background checks, I have all of their information. They were cleared. They came into a meeting. Had they just worked with her, it would have been fine. But they came to our morning meeting, our administrative meeting. They sent all of us home just a little while after that. I stayed in my office by myself and continued to work. But she caught that because they brought that here from out of state. It's how that is legit. I mean, they were coughing and doing their thing and whatever, and I mean, how it went, got rejected and sent back. They never told any of us to testify.
Well, and
should they have done that?
Well, from her perspective, possibly, but it really, and the reason why the ICA found the decision was invalid was because the Board of Review didn't do any kind of proper analysis in the case. So I'm not really sure what happened at the Board of Review, what evidence was submitted. All I know is that we have the parameters for an occupational disease in West Virginia, and the Board of Review did not do a proper analysis based on those factors. And it's not really easy to establish an occupational disease in West Virginia, particularly for something like COVID, where you're equally exposed in the general public. And in Ms. Foster's case, it seems like she was going out. If she had been staying at home for those 2 weeks, it could have been a very different scenario. But apparently, at least based on the evidence that was submitted to the Board of Review, she was going out doing other things in that time. So there was no way to establish that the only exposure she had was at work, and she actually contracted COVID because of that exposure at work. And that's ultimately why it resulted in the way that it did. So if different evidence had been submitted, who knows, it could have been a totally different scenario, but that's what happened. And I don't know what happened. The because like I said, it got remanded to the board review. I'm not really sure what happened after remand either, so, you know, who knows? And so another thing I wanted to mention, another ICA decision that was significant was regarding apportionment of pre-existing condition, and that's the Duff-Beacon County Commission case. So this case affirmed a board of review decision regarding apportionment of permanent partial disability or PPD. So this opinion was also a very extensive analysis. It was about 24 pages, and it provided a detailed analysis for determining when apportionment is appropriate for pre-existing diseases and versus a compensable injury. So in the case, there were two different PPD ratings. One was a 13% and one was 25%. In both cases, the physicians at issue that examined this individual, they found all person impairment of 25%, but the first physician apportioned 12 of that to pre-existing issues. And the other physician felt that all of the impairment, the full 25%, should be attributed to the work injury. So the board review and the ICA ultimately determined that apportionment can be appropriate even without quantifiable information, so long as the apportionment is based on competent medical evidence. So what that means is, in the past, physicians have failed to apportion impairment for PPD purposes when there's no either prior PPD award or there was no range of motion testing, something like that, to give a quantifiable number for them to look at and say, okay, this is the amount that should be apportioned to these pre-existing issues. Well, in this case, they didn't have any prior award, there was no range of motion testing. However, they did have significant medical records showing that this person had prior back injury and had been treating for this injury, and these prior injuries with his back were preventing him from fully participating in activities of daily living. So he was having a lot of pain, he was getting a lot of chiropractic appointments, things like that. And the board review and the ICA felt that that was sufficient information to justify apportionment. So this is a good case for carrier purposes. So now we know we don't have to just have prior PPD rating, we don't have to have range of motion testing in order to have apportionment for PPD purposes. And in this case, 13% versus 25% is a big difference in PPD. Okay, and that's all I have. Does anybody have any questions? All right, thank you.
Thanks.